presidential immunity case, the one case from this term that provoked the most controversy, the most fury. Did the court hold Trump immune or didn't it? He's charged with conspiracy to obstruct an official proceeding, conspiracy to defraud the United States. One of Trump's motions, dismiss this case, Your Honor. Dismiss it on grounds of presidential immunity. We did not have any law on the issue of presidential immunity from criminal prosecution until now. You need immunity to protect all presidents. It's not a partisan issue. The Constitution matters. The law matters. What I'm going to do is walk you through this case straight down the middle. Hello, everyone. I'm Jed Rubenfeld, a professor at Yale Law School, and today in this episode, I'm going to be talking about the big one, the presidential immunity case, Trump versus the United States. This is the one case from this term that provoked the most controversy, the most fury. But what did the court actually do? What did it say? If you're not sure about that, you come to the right place, because I'm going to explain. I mean, did the court hold Trump immune or didn't it? Did the court actually say that the President of the United States can commit murder? If you're confused about these issues, you're not alone. So what I'm going to do is walk you through this case straight down the middle. Now, the first thing I want to do is I want to respond to people who say, you know what, I'll tell you what happened in this case. The pro-Trump justices wanted to see him held immune, and that's the way they decided this case. They decided in favor of Trump because they're pro-Trumpers. I can't stand that. That's wrong. That's too simplistic. And you know what? You get the opposite problem on the other side where people say, you know why the dissenters dissented in this case? Because they hate Trump, and that's why they dissented. No, that's wrong too. Way too simplistic. Let me give you an example. In what might have been the single most important case of this Supreme Court term, Trump versus Anderson, this is a case out of Colorado where the Colorado courts decided they could disqualify Trump from the ballot. Well, if that had stood, we'd be in a different country right now. But the Supreme Court struck that down. They found it was unconstitutional. And why am I bringing that up? Because they did it unanimously. The three justices, they're called the liberal justices, they joined that opinion too, and that was a great opinion for that reason alone. That's an opinion to celebrate, and the court got the Constitution right. And that's the kind of case you got to remember when people say that the justices are deciding this because they're pro-Trump or deciding that because they're anti-Trump. Constitution matters. The law matters. I'll give you another case. Murphy versus Missouri. This case was the biggest win for the Biden administration in this term. What case was that? It's the First Amendment case where the Supreme Court reversed the Fifth Circuit. Fifth Circuit had said the Biden administration had engaged in a massive attack on freedom of speech through the way they were inducing social media companies to censor speech. Supreme Court reversed. Now, if you've been watching my show, you know I agreed with the Fifth Circuit. So I was disappointed by that case. But here's the point. Several conservative justices joined that opinion. I may disagree with it, but that doesn't matter. What's important here is they weren't deciding because they were pro-Biden or anti-Biden. They decided on what they thought was the best view of the law, and that's something to be celebrated. It's important. So I would just ask you to bear those cases in mind when you hear people jumping up and down and blasting a case they don't like, saying it's decided the way it was all because the justices on the court are Trump justices or pro-Trump or anti-Trump or whatever they're saying. Bear those kinds of cases in mind because I think those help when you get that cynical worry, as I sometimes do, that it's all partisan politics all the way down. No, it's not. Let's not give in to that. Not yet. So, what about this case, the immunity case, Trump versus the United States? Okay, first question. What was going on with this case? What's it about? Well, Trump versus the United States, it's one of the several criminal prosecutions going on right now against former President Trump at various courts, various parts of the country. This is one of the federal prosecutions. Special prosecutor Jack Smith brought this case in Washington, D.C., concerning the events having to do with January 6th. It's called the January 6th case. What are the charges? Well, they're kind of unusual. Is Trump charged with insurrection? No. Is he charged with incitement to riot? No. Is he in charge with sedition? No. What's he charged with? He's charged with conspiracy to obstruct and actually trying to obstruct an official proceeding. For what official proceeding? Well, the meeting of Congress to count the electoral votes. Okay, so that's one charge in the case that might strike you as familiar because the Supreme Court just dealt with that kind of charge in another case, Fisher, and I'll come back to that later. Another charge in the case, conspiracy to defraud the United States. What? How was Trump defrauding the United States? Well, the theory of this case is Trump knew he had lost. He knew he had lost. He didn't think there were any voting irregularities or voter fraud that could have changed the election. He knew he lost. But he lied, and he said that there were sufficient acts of voter fraud to have changed the elections. Didn't believe it. He was lying to everybody. And then he went out and made a plan with some people to try to get some legislatures to create alternative slates of electors and send their electoral votes to Congress, which might conceivably, possibly have been a possible thing to do if there had been voter fraud, but he didn't think there was voter fraud, so those were fake electors, and the whole thing was an act of fraud. Okay, so those are the charges, and from a legal point of view, they're a little unusual, and I'll get back to that. I'll explain exactly how they're unusual and why that's important, but for now, let's move on. So what happens next? Well, what happens next is there's a ton of motions in the case. Trump's lawyers are throwing all these motions out there. Government's responding, making its own motions. One of Trump's motions, dismiss this case, Your Honor. Dismiss it on grounds of presidential immunity. Throw the whole case out. They're charging Trump with crimes based on conduct that he took when he was president. He can't do that. President's immune. Can't charge a former president with crimes based on actions he took while he's president. Throw the case out. Well, what's the law say about that? Is the president immune from criminal prosecution? Believe it or not, there was no law on that issue. We did not have any law on the issue of presidential immunity from criminal prosecution until now. Why was that? Because there had never been a former president prosecuted for conduct taken while he was in office as president until now. So there was simply no case law. But there was case law, interestingly, on a related issue. The issue of whether a former president is immune from a civil suit brought against him based on conduct taken while he was president. Well, Professor, what does that mean? What's a civil suit? I'll explain because it's easy. Civil in this context just means non-criminal. And 40 years ago, in a case called Nixon versus Fitzgerald, Supreme Court said absolute immunity. You can't sue a former president in a civil suit for acts he took as president. And why? Why did the Supreme Court so hold? Did the Constitution say that the president's immune from such suits? Civil suits, well, that's one guy suing another guy for damages, and the court saying you can't do that. Does the Constitution say that the president's immune from civil suits? No, it does not. But the court said this. They said, look, the Constitution assigns the president all the executive powers, and he's got a duty and a constitutional responsibility to exercise those powers in the best interests of the country. And you want your president to be able to make bold and courageous decisions if he has to in the best interests of the country. But look what would happen if he had to worry about the possibility that he's going to be sued in damages after he leaves office. This is how the court reasoned its way through the case. If we allow damages suits after the president leaves office, he's going to know that while he's in office, and that could have an effect on how he makes his decisions. Maybe there's choice A he could make that's in the best interest of the country, and that's what he wants to do. But if he does that, he might get sued for damages after he leaves office. And the legal bills alone could be crippling, and the damages could totally bankrupt him. And so maybe he chooses choice B, where it's not what he would do solely in the best interest of the country, but he's protecting himself from potential damages suit. And the court says we cannot have our president thinking that way. Damages suits after a president leaves office could have a serious, intrusive effect and chilling effect on how he exercises his powers in office while he's in office. So for that reason, says the court, in Nixon versus Fitzgerald, absolute immunity from civil suits even after he leaves office. Well, guess what? You can imagine what the Trump lawyers did with that. So in their motion to dismiss, they said, oh, you think a civil suit would be intrusive? Well, a criminal prosecution is going to be 10x that. President's worried about a criminal prosecution after he leaves office. That's going to have a much more intrusive and chilling effect on decisions he might make while in office, so he should be immune. But what did the government say in response? They said, first of all, a prosecution Criminal prosecution, that's a much weightier interest than just one private person's damages suit against the president. When you're talking about criminal prosecution, you're talking about the whole nation's interest in enforcing its laws. That's way more weightier. And on top of that, there's something else, a little something called the principle that no one is above the law. Because listen, if the president's already immune from a damages suit and now you hold him immune from a criminal prosecution, well, then he's got no legal accountability at all. And you can't have a president totally immune from any legal accountability, then he'd be above the law. So those are the issues. Those are the arguments on both sides. And when this case gets to the D.C. Circuit, what did that court do? It sided with the government. And the D.C. Circuit said, no immunity at all. When the president leaves office, absolute zero immunity. Forget absolute immunity, zero immunity. Once he leaves office, he goes from President Trump to Mr. Trump, and he can be criminally prosecuted just like anybody else. I don't care if the acts were taken while he was in office. It doesn't matter. He's criminally prosecutable. And the court said, we're therefore remanding to the district court and let the prosecution of Trump begin. But Trump's lawyer said, not so fast. We're taking it to the field of the Supreme Court. We're going to petition for a writ of certiorari, which is how the Supreme Court takes cases, and they granted that writ of certiorari, and they said, we're taking that case. And the minute they took that case, you know what a number of us said in response? And if you've been following me, you've been watching my show, you know I said this. I predicted this before the case came down. What we said was the D.C. Circuit went too far. They didn't have to say zero immunity, but they said that. So now the Supreme Court had to take that case. They're going to reverse. They're going to say, look, it's not zero immunity. Here are the standards. Here's the proper test to apply to decide if the president's immune after he leaves office from prosecution for acts he took while he was in office. We're going to lay down the test. We're going to give you the standards that courts ought to apply, and we'll kick it back to the lower courts to apply those standards. And guess what? That's exactly what the Supreme Court did. Now, you got to remember, Trump's lawyers were in there saying, absolute immunity. They were taking the exact opposite position from the D.C. Circuit and from the government. That was zero immunity. Trump's lawyers say, look, if a president hasn't been impeached, you can't touch him at all. He's immune for whatever. I don't care if he committed murder. He's immune. Well, the Supreme Court rejected both the extreme positions. They said, it's not zero immunity. It's not total immunity. Here's what it is. So what was the test that the court laid down? All right, it's a little complicated. I'm going to walk you through it. The first thing the court says is you got to distinguish between official acts and non-official acts. You got to first decide, was the president acting in his official capacity as president, or was he acting in his personal or private capacity not as president? Because if the president was not acting in his official capacity, forget about it. He's completely prosecutable, zero immunity. That's when there's zero immunity. If he's not acting in his official capacity, no immunity at all. So this distinction between official and unofficial is pretty important. Well, what's the distinction? Guess what? It's not always easy to apply. But here's the concept. The concept is, was the president exercising one of his powers as president? The president has a bunch of powers. Some come from the Constitution, some come from statutes. If the president was exercising one of the powers he has from the Constitution or from a statute, then it's an official action. But if he wasn't, it's unofficial, and he can be prosecuted. So what's an example of a non-official act? Well, I'll give you an example. It is a little extreme, but it's a classic example of non-official. Let's say President John F. Kennedy, decades ago, had gotten it into his head that his wife, Jackie Kennedy, was having an affair with somebody, and he drives off in the middle of the night to the home of the guy he thinks Jackie is having an affair with, and he shoots and kills the guy. Is he exercising one of his powers through the Constitution or through a statute? No, he is not. He's acting in a private capacity. It's personal. It's a private matter. He's not acting as president. He's not exercising any of his presidential powers. So is he prosecutable because he committed a crime, murder? No, that's not why he's prosecutable. Distinguishing between official and non-official isn't a matter of whether what the president did was lawful or not. It's a matter of whether he was exercising one of his powers. In the case of President Kennedy going off and killing the guy he thinks his wife's having an affair with, not exercising a power, not an official act, therefore zero immunity. Okay, so that's step one. Zero immunity if not exercising one of his powers. Now, what if he was exercising one of his powers? What if he was acting within his official capacity? What then? Well, here the court distinguishes between core powers and non-core or perimeter powers. What are core powers? What the heck is that? Well, the court says, look, as we have recognized in prior cases, there are some few things that the Constitution entrusts solely and exclusively to the President. Those are his core powers where he has plenary, exclusive, sole authority under the Constitution. The Congress can't say anything about it. Nobody else can say anything about it. The decision is solely entrusted to the President. What's an example? The court gives a couple of examples in the case. One example they use is the presidential pardon. Congress can't start regulating how the pardon is issued or what effect the pardon has. No, Congress has got nothing to say about that. That's a core exclusive power to the President. Here's another, suggests the court. Firing a cabinet officer. Congress can't get in there and regulate that and pass laws telling the President when or if or how he can fire one of his cabinet members. That's solely committed to the President, suggests to the court. And again, that would be him acting within his core powers. If the President is acting within his core powers, what's his level of immunity? Absolute immunity. So, unofficial, zero immunity. Core powers, complete, absolute immunity. But for everything else, and most of what a president does, he's outside the core, but he's acting within his official powers. I'll give you an example. The president has tons of power over immigration. You know that. The president has lots of decision-making power over what happens at the nation's borders. But guess what? So does the Congress of the United States. Congress is given power under the Constitution to regulate immigration, to pass the laws that govern immigration and naturalization, to regulate how things happen, who can get in, who can't get in. So this is an area of concurrent power. Immigration, what the president does here, he's got plenty of power, but he shares that power with Congress. And in that zone, and that's most of what a president does, the president is not acting within his core power. He's acting outside the core, but it's still official. What then? Something the court calls presumptive immunity. What the heck is that? Well, basically, the idea is simple. When a prosecutor tries to prosecute him, and they can, if he's acting outside his court, the prosecutor can try to, government can come after him. He can be prosecuted, but the government's got to rebut that presumption of immunity. The president comes in with a presumption of immunity, but the government can rebut it. Well, how? How could the government rebut it? Well, what the court says is the government's got to show, through evidence, that the kind of prosecution it wants to bring against the former president for something he did in office, even though it was official, won't be too intrusive and too much of a hindrance on the president's abilities and powers to discharge the functions of his office while he's in office. You got to let us bring this kind of charge, the prosecutor will say, and because allowing us to bring this kind of charge won't affect how a president discharges the official powers much at all. Well, how is a prosecutor supposed to prove that? What kind of evidence does he bring in? Answer, we don't know. It's a brand new standard. It's never been applied. Supreme Court kicks that back and says, lower courts, you got to apply that standard. And guess what? We won't know what it means until courts start enforcing it and applying it, assuming they ever do. Okay, so let's step back. What happened in the case? 3 levels of different kind of immunity. Unofficial acts, 0 immunity. Official core acts, absolute immunity. All other official acts, presumptive immunity. Then the court starts going through the charges against, current charges in the January 6th case against Trump and making some remarks about whether he's immune and what test applies. For the most part, the court doesn't say anything definitive, but with respect to the most important charges, the court says this. Hey, lower courts, Trump might not be immune at all. It might be 0 immunity because they might be unofficial acts. What charges are those? What might be unofficial? Well, the January 6th charges, the court says, allege that Trump did things on January 6th, like encourage people to go into the Capitol and make arrangements with state legislators to forward alternate slates of electors. Well, maybe he was acting solely as a candidate for office. Maybe he wasn't acting as president. A candidate for office doesn't have office. If President Trump was acting solely as a candidate and not as president, that's unofficial. Zero immunity. And we're going to let the lower courts decide that. So that's very important. The court did not hold Trump immune from the January 6th prosecution. On the contrary, the court said that Trump might have zero immunity for the most important charges in the case. So why is everybody so upset about it? Why is everybody jumping up and down and screaming about this case? Well, for one thing, as you know, the practical result of this case is that January 6th case, it's not going to get prosecuted before the election. And a lot of people are very upset about that. By the time the lower court rules on whether it's an official act, whether there's immunity, that'll have to go up to appeal, probably to the D.C. Circuit again, and then that will probably have to go up on appeal to the Supreme Court again. There's no way this trial happens before the election. So a lot of people see that practical reality, and they're very mad about that, and that's what they say is so wrong with the majority. That's not really a legal reason to oppose it, and that's not what the dissenters said. The dissenters, and there was a very strong, vituperative dissent. They didn't object to the decision on that ground. Justice Sotomayor, in her very strong dissent, says, think of what you have just done. You have said that if the president orders SEAL Team 6 to kill a political rival, the president's immune. Can't touch him. If the president takes a bribe for issuing a pardon, you, the majority, you've just said you can't touch him. He's immune. Prosecution, go away. You have, in essence, said, this is Justice Sotomayor describing what the majority did. You have, in essence, said that the President of the United States can commit murder and get away with murder. And that's, if you're reading what people are saying about the case, that's what they focus on. They say that the majority, in its pro-Trump zeal, has given a free license and free rein to the president to commit murder and get away with it. Well, is that true? Was that a fair reading of the majority? Well, here's what some people are saying in defense of the majority. They say, well, that's ridiculous. If the president ordered SEAL Team 6 to kill a political rival, he's acting outside his official powers. Here's why. The Constitution gives the president commander-in-chief powers, but only to order the military to defend the nation against military enemies, to defend national security, to defend the nation against military threats and defend it against military enemies. That's what he can do with his commander-in-chief power. And if he's ordering SEAL Team 6 to kill a political rival, he's not exercising one of his powers. If that's true, if that's the simple answer, then Justice Sotomayor was way off on that point. But is it that simple? It may not be that simple. Justice Sotomayor could say, well, hang on, the majority says you can't look at the motive when the president is acting within his official powers. The majority goes out of its way to say the one thing you can't inspect is his motive. And if you can't inspect his motive, then you don't know whether he was ordering SEAL Team 6 to do something to protect us against a military enemy or to protect us against his political rival. So if you can't look into motive, you don't know. So it looks like an official act, and he's immune. Well, it's very confusing. I got to be honest, what the majority says about motive, very confusing. Now, it's possible to get around that. I have a brilliant former student of mine who graduated a couple years ago. His name is Toby Calvert-Lee. Hope you're watching, Toby. And Toby has this suggestion. He says, look, you don't need to look at the president's motive to find the president not immune in that circumstance. Why? Because you could ask an objective question. Would any reasonable person have been able to conclude that this political rival was a potential military threat against the United States? If no reasonable person could have concluded that, then the president is not acting in his official capacity. He's not exercising a power given him by the Constitution, and he's not immune. End of story. Well, that's a possible way of understanding the case. But here's what I wish. I wish the Supreme Court had said something about it. Justice Sotomayor's questions are totally legitimate. Her objections are legitimate. Why doesn't the court say something clearer in answer to her hypotheticals? It didn't really. How about her hypothetical if the president takes a bribe for issuing a pardon? You can't tell what the majority's view of that is. They just don't say. I mean, on the one hand, Well, the pardon, they told us, is core power, so maybe you just can't touch the president. Maybe he's totally immune. On the other hand, they drop a long footnote suggesting that in a bribery prosecution, you're not actually charging the president for his exercise of his official power. You're just charging him for taking money in exchange for it. And they argue this point in the long footnote. You can't totally tell what they're saying. So I'll tell you honestly, I read the footnote, I've read the opinion. I'm not sure what the majority thinks the situation is under their own test if a prosecutor tried to charge a former president with having accepted a bribe for a pardon. We just don't know. We're not sure. And that's a flaw in the majority opinion. They should have done a better job responding to and rebutting those arguments. But now let me get to a flaw in the dissent. The dissent doesn't do as good a job as it should have responding to a different danger, different problem. And that's the problem of weaponized, politicized prosecutions. Look, anybody reasonable out there, I don't care your views of Trump, whatever you think about him, anybody reasonable should understand that it's very dangerous to allow the criminal justice system to be used to prosecute political opponents, political enemies. We can't let that happen. That's a recipe for disaster. It's a recipe for democratic disaster, constitutional crisis. Criminal justice system cannot be used to prosecute political enemies because you hate their politics, because they're a political enemy, because you don't want them to win office. Now, I know there's a lot of people out there saying President Trump, should he win office again, he should go after his political enemies. He should. He has a right to. They did it to him. He should too. Well, here's a simple answer to that. No, he should not. It's unconstitutional. You want to live in a world where former presidents and political candidates can be charged for crimes by prosecutors who are appointed by or elected by those in the other party? You got a very bad situation for democracy if you let that happen. Now, no one is above the law. Yes, of course, prosecutors should be able to go after anybody. I don't care if he's a former president, political candidate. If he commits a murder, he got the goods on him, of course, he should be prosecutable, and he should be held to answer for that crime. But if, instead, the prosecution has to apply criminal statutes in a brand new way and charge the person under a statute, under an interpretation of that statute that's never been done before, then you start getting into problem territory, because then you're opening the door to political prosecutions. And that's why it's important that the charges against Trump, in this case, the January 6th case, are unusual. Said I'd tell you about it in more detail about why they're unusual, why it's important. That's what I'm doing. So that obstruction of an official proceeding statute that President Trump is charged under, well, it looks like that statute had never been applied before in the way that it's being applied to the January 6th defendants. Now, if you heard my episode on the Fisher case, you know what I'm talking about. And the Supreme Court pretty much upheld that view. They said, you're taking a statute that was written and drafted to prohibit tampering with documents, tampering with witnesses, forging documents, destroying documents, and obstructing official proceedings in that way and in other similar ways. And you're reading it to prohibit all obstructions of official proceedings. You're making a mockery of the whole statute, the statutory scheme. We won't allow it. Well, whether you agree with the Fisher case or not, you've got to be incredibly careful when a prosecutor appointed about officials in one party are going after a former president from another party based on a brand new, never before tested theory or interpretation of a criminal statute. This should be a nonpartisan issue. President Biden leaves office. You know what could happen to him? Some enterprising prosecutor, whether it's a local prosecutor, federal prosecutor from a different party, they could charge him with crimes. You could have a local prosecutor who says, you know what, I think your immigration policies were terrible and reckless and negligent, and they were letting all these people cross the border, and one of those people killed somebody in my state. Well, I'm going to charge you, former President Biden, with reckless or negligent homicide based on those facts. It was your negligence that let the guy in. You're responsible. I'm charging you with negligent or reckless homicide. You can't let that happen. You may hate President Biden's border policies, but you cannot allow opposition to presidential policies to be a basis of prosecuting somebody after he leaves office. That's just a recipe for turning us into a third world country. It would be a disaster. You need immunity to protect all presidents. It's not a partisan issue. Somebody else could say, you know what? I think President Biden is defrauding the United States. A clever prosecutor could charge him under this statute that prohibits defrauding the United States. He lied in the United States. He lied in many ways. He lied about the border. He lied about his mental health. That was fraud. And that's defrauding the United States. And it was interfering with an election. So we're gonna prosecute him for. Again, that's not what you want your prosecutors to be doing after a president leaves office. You cannot prosecute someone because he's your political enemy, because you don't like his policies. It's unconstitutional. And our courts right now need to stand up to that possibility and to lay down rules to prevent it from happening now in order to prevent it from happening later. So I know a lot of people disagree with this immunity case. But if you want the rule of law to be of paramount importance, and if you want the Constitution to be of paramount importance, that's what our courts need to be doing. They need to be standing up, laying down rules, good, strong rules, to prevent politically motivated prosecutions. One way you do that is by preventing prosecutors from creating brand new interpretations of criminal statutes that they've never done before. You say, no, they can't do that. You apply those rules fairly. You let the lower courts apply them. You apply them in future. If you take that view of this case, the immunity case, well, you got an argument in favor of it. Because that's what the court did. Lays down some rules to protect against politically motivated prosecutions, which are unconstitutional. It says, look, we got to apply those rules now in order that we have those rules in place, and they will protect future presidents no matter what party they're from. Well, that's all from me for now. Hope you enjoyed watching, and I hope you'll stay tuned for more episodes of Straight Down the Middle.